welcome back to another episode of Law Schoolers. We are now transitioning from our Fourth Amendment discussions about reasonable searches and seizures and the requirement for a warrant and all these kind of things. And now we are moving on to our Fifth Amendment discussions about interrogations. So what aspect of the Fifth Amendment is actually applicable in this part? Well, it says, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. That is referencing to the rights of the defendant in the Fifth Amendment. And so interrogations are a large portion of this. In this episode, we are going to primarily focus on the due process limitations on voluntary confessions. Why is this our focus? Well, confessions are largely important to the prosecution. The vast majority of cases are actually resolved by confessions. So, for this reason, the officers engaged interrogations, and the whole purpose of the interrogation is to obtain incriminating information that can be used against the defendant at trial. The limitation here is that all confessions must be voluntary. This is very similar to the standard that we had when it came to consent, where all consents underneath the Fourth Amendment for searches need to be voluntary as well. That is, they can't be coerced. And so now we're going to be talking about how to tell whether or not a confession is voluntary or not. One other thing before we talk about what actually outlines what is voluntary and what is not is the burden of proof is on the prosecution to show that this confession was voluntary, and they need to do that by a preponderance of the evidence. That is the standard for that. Well, how can you tell if something is voluntary or involuntary? Well, let's just say if it's involuntary, well, then it's not voluntary. So let's talk about what makes a confession involuntary. Well, it's if the officers engage in physical abuse or deprivations of the individual, if the officer engages in promises or threats against the individual, or if the police lies to the individual. And so now we need to determine whether or not these things are actually going to, or what impact these kind of factors are going to have. Let's start with physical abuse and deprivations on the part of the police against the defendant. In 1931, the Wickersham Report outlined the use of the third degree, which the third degree was physical abuse tactics that were used to coerce confessions. In 1987, the court cited Bram versus United States and held that the Fifth Amendment prohibited police coercion in obtaining confessions underneath the federal law. The following case that we're going to talk about, Brown versus Mississippi, describes the court extending the requirement to apply to the states too. In other words, this was the case. Brown versus Mississippi is the case that causes Fifth Amendment to be incorporated to not only federal cases, but also state cases. So Brown versus Mississippi, what happened here is that the officers engaged in torture and to obtain a confession against the defendants. Yeah. I won't get into all the details. I do want to share some, but the officers believed that the defendants had engaged in a crime and took the defendants into custody and tortured the defendants until they confessed to the crime and confessed to it in the exact way that the officers told them to confess to it. Their confessions were inconsistent. They were shaping with how the mob wanted their confessions to be. And for these reasons, it's just a question of reliability about the confessional in the first place. So what are our takeaways from this? Well, our rule of law is that physical abuse to prisoners to obtain a confession is going to be void, meaning that confession is void, because it's a violation of a due process within the Constitution. This is going to apply, as I mentioned, incorporated to both federal and state courts alike. The right against self-incrimination is so important and fundamental to the Constitution that its protections need to be afforded to all criminal defendants, regardless of whether or not that's federal or state. The defendant's privilege, in this case, Brown versus Mississippi, was violated because of the coercive behavior of the deputy. Because, one, torture is different than self-incrimination in the first place, and second, the states can't justify it can't just violate due process principles based off of a fundamental right that people have against this kind of treatment. So after Brown, the use of third degree, as I had mentioned, third degree is pretty much physical abuse of individuals. Those interrogation tactics pretty much vanished. There are other deprivation cases, though, other than physical abuse, but these cases are much, much, much less common now. They rarely happen. A couple of examples of these is pain, which was a deprivation of food, fikes, which was putting the defendants into isolation. You have Ashcraft, which referred to the time of interrogation being long throughout the night, so on and so forth. And then you have McNabb and Mallory, which talk about the delay in taking the defendants to court, having their first court appearance, that is. And then finally you have Haley, you have Haley, which talks about the age of the individual who may be receiving this treatment, and then Beecher talking about whether or not the individual has a particular vulnerability that other individuals might not have. Okay, so if the officers are engaging in physical abuse or deprivations, it's going to be a violation of the Fifth Amendment, and any confessions obtained through those means is going to be excluded evidence. That confession cannot make it in a trial. Let's talk about promises and threats. What can the officers promise? What can't the officers promise? We have State versus Swanigan. What happened here is a robbery, and the officers took Swanigan into custody, began to question him, made him promises, and from these promises, obtain a confession. Well, based on the totality of the circumstances, here's our rule: if the officers' comments threaten charges or promise retribution to the individual, and that individual has diminished capacity, and those threats and promises cause the actual confession, well, then any statement taken by that defendant is not going to be admissible at trial. So let's talk about the totality of the circumstances in this case, State versus Swanigan. The confession here was involuntary, although each piece of statement that the officers made to the defendant was not enough to say that the confession is involuntary. That is, the officers are free to say that they will pass on information relating to the defendant's cooperation, but taking all the statements that the officers said to Swanigan together, everything points to the information being involuntary and coerced based off of the promises and threats that was made. It's also clear from the officer's statement that these statements did have an effect on Swanigan, because his story would change after each new threat or promise was offered to Swanigan. So essentially, the threat and that failure to confess will be conveyed to a prosecutor is going to be a violation of the Fifth Amendment, because it is a threat against the right to remain silent. This threat against silence alone isn't going to automatically determine that the confession was involuntary. The court is also going to consider the age, the intellect, the familiarity with the judicial system. They're going to consider all these things based off the totality of the circumstances. In other words, if the subject knows that they have the right to remain silent, and the threat of silence, then the threat of silence isn't going to violate the Fifth Amendment as far as a involuntary confession goes, because they know that they had the right to remain silent. So what kind of promises can the officers do? What can or cannot the officers do? Well, when it comes to promises, they can promise to convey notice of cooperation to the prosecutor. They cannot promise to convey notice of the lack of cooperation. They cannot promise lesser charges for confessing, because that's not the officer's job there. That's the prosecutor's job to determine what the result of the litigation is going to end up being. So those are things that the officers can. They can convey cooperation notice, but they can't say, you didn't cooperate, we're going to pass that along. Or, if you say this, we're going to lessen your charges. As far as threats, what can't the officers say there? Well, they can't threaten more charges for lack of cooperation. Okay, we have State versus Carroll. What happened in State versus Carroll? Well, the defendant was 19 years old, went with his mother to the police station as he was being suspected of murder. The mother was also a police officer in this case, and that's kind of important. The mom is also a police officer at this station, but was not acting as the role of the officer, or at least was instructed not to act as the role of the officer during the interrogation of her son. During the interrogation, the mother did tell her son to confess, saying it would be worse for him the longer he waited. The defendant in this case said he was afraid of the others involved in the murder, and the police told him that they would discuss his protection if he confessed. So, there's two potential promises that we see in this fact pattern. It's going to be worse for him the longer he waited, or that the officers could discuss protection if he confessed. Well, the court in this case said that the confession was voluntary. Importantly, even though the mother was a cop, she was not acting as a cop in the statements that she made to her son, saying it would be worse for him the longer he waited. That could be her belief, and that could be a moralistic belief as well, but essentially she was acting as his mom, not as a cop, in making that statement. And then the request for protection, that may seem as coercion, but here the officers only explain the potential options, meaning if you confess, we will discuss protection. That doesn't mean that you will be protected. The officers didn't say that part, but we could discuss protections. So in all, the mom's influence caused the confession, not police coercion, and that is completely fine. Okay, our last thing that we need to consider is police lies. What happens when the police lies, and when is that going to infringe on this voluntary confession matter? We have People versus Thomas. The rule outlined here is that under the totality of circumstances, if false statements made by the police have an impact on the defendant in coercing a confession, then those confessions must be suppressed as a violation against the right against self-incrimination. Let's state this rule just based off of a quote in the text. It says, the statements were not products of coercion, either physical or psychological, or in other words, that they were given as a result of free and unconstrained choice by their maker. Court is not saying that all lies are out, only multiple lies, but one could be enough to say that the confession is out. Powerful lies are going to be out because those powerful lies can be used to overcome the free will of the subject. So what are we going to consider when the officer is lying to the subject? We're going to consider the circumstances considering the question. We're going to look at the age, the experience with police officers, or the education of the subject. We're going to look at the mental condition of the subject, and then we're also going to look at police coercion or trickery when they are trying to come up with a confession. What are some examples of lies that lead to the exclusion of evidence? Well, in Linam, I think that's how you pronounce it, the officers cannot say, hey, you lost the benefits to your kids. You will lose benefits and you will lose your kids if you don't confess. Another lie that officers can't say comes from Spano, saying we will tell your friends if you don't confess. Examples of lies that are admitted, though, is in Conti, which says a fake lie detector test. You can lie about the results of a lie detector test, I believe. And Davis is another example. It says that you can say that a co-defendant admitted something that is incriminating to you as well. Let's talk about the facts of People versus Thomas and talk about whether or not the lies here by the police was coercion against Thomas. Well, Thomas in this situation, he had acted pretty violently against his child, his baby, and the baby was rushed to the hospital after being unresponsive and ended up dying. Thomas, as the mom was at the hospital, was taken into interrogation. He was pretty distraught. This was not his only kid. He had several kids, and so he was pretty distraught about this one. Before the baby's death, Thomas was told that if he did not confess, his wife would take the blame. It's not true. He was told several times that the injury had been an accident. Although the physician had said that this was murder. He was also told that he would not be arrested if he confessed. So the baby died, and then after the baby died, and Thomas was told that the baby was not dead, and that the doctors needed his confession in order to have knowledge that was necessary to save the baby's life. Based off of this, Thomas confessed that he had accidentally inflicted an injury. When confronted with this, saying that there's no way that the injury sustained by the baby could have been accidental, Thomas was given a prop, asked to demonstrate what he did, and he did so, and then those actions were admitted as evidence for his conviction, and he was convicted. Now it's a matter of whether or not this evidence should have been excluded. What happened here is that the confession was involuntary and should have been suppressed. So several lies, big lies. The mental state of the defendant was obviously really, really at issue here. And for these reasons, the evidence should have been excluded. All right, and that's everything related to this material. We talked about 3 things that might make confession involuntary. If the police are engaging in physical abuse and deprivations, if the police are making promises and threats, certain promises and threats, and then if the police are making lies, and particularly big lies, to the defendant. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.